Taking you now back to Washington, D.C. and Capitol Hill, where the House impeachment managers appointed to act as prosecutors in the Senate trial of President Donald Trump are speaking right now. Let's listen.
Used in the Clinton trial. To begin with, and this is, I think, most indicative, in the Clinton trial, both Senate leadership worked out a bipartisan proposal for how the trial would be conducted. That obviously has not happened here. Senator McConnell did not consult at all with Senator Schumer on the contents of this text. I would imagine that Senator Schumer only got to see it probably around the same time that we did in the House. And the reason this was kept hidden is that it does not prescribe a process for a fair trial. And the American people desperately want to believe that the Senate will give both the President and the House of Representatives a fair trial. This resembles nothing like the Clinton proceeding. For the first point, in the Clinton case, if we're truly following the Clinton precedent, all of the documents were provided before the trial, more than 90,000 of them. Does this resolution provide for the President to provide the documents before the trial? No, it does not. It leaves that question of whether the House will ever see these documents, whether the American people will ever see these documents, to the end and only the end, with no guarantee that this material will ever be shown to the House or to the American people. That is a profound departure from the Clinton trial. Without the documents, you can't make important judgments about even which witnesses should be called or what questions should be asked of the witnesses when you do. So that is a profound departure from the Clinton precedent. On the subject of witnesses, it is also a deep departure from Clinton, where all of the witnesses testified before the Senate trial. The issue in the Clinton trial was not whether they would testify. They had testified already. They had been interviewed already, some dozens of times. The question in the Clinton trial was, will they be recalled? Will they be required to testify again? And that question was answered in the affirmative. Here, though, if we're following the Clinton precedent, all of these witnesses should testify, should be deposed before the trial begins, not after the trial is over. So this is not at all the model used in the Clinton case as well. This resolution even goes so far in another departure from the Clinton precedent to say they're not even going to admit the evidence that was received in the House, that they're going to even postpone the decision about whether any of the witness testimony will actually be part of the record. And finally, they are compressing the time of the trial. Whereas the Clinton trial, managers had 6 hours a day to present over a course of days. They're now presenting that we double the amount of time each day so that the proceedings can conceivably go well into the night when apparently Senator McConnell hopes the American people will not be watching. This is not a process for a fair trial. This is the process for a rigged trial. This is the process if you do not want the American people to see the evidence. This is a process you use if you want to, hand in hand, working in concert with the President, allow the President to continue to obstruct the Congress and deny the truth to the American people. Thankfully, however, we know the truth. The evidence is already overwhelming, and that evidence is that the President abused the power of his office, withheld hundreds of millions of dollars of needed military aid to an ally at war in order to coerce that ally into interfering in our election. And then when he was caught, obstructed the Congress to cover it up. That truth is inescapable, no matter how McConnell wishes to structure this trial. But we will be appealing to the manager, we will be appealing as managers to the senators today to live up to the oath they have just taken, to do impartial justice, and to hold a fair trial. And we're happy to respond to questions.
Let me add something here. I just want to add that this fixation on the Clinton precedent is weird. The Clinton trial was conducted fairly, but distorting what happened there shouldn't make a difference. The question is, should you have a fair trial now? Any intelligent person knows that in any trial, whether it's for robbing a bank or for subverting the Constitution of the United States. The accusers, in this case the House of Representatives, bring in all the witnesses and all the evidence. The defenders can bring in all the evidence they want. That's how you have a trial. To be debating whether you should have the evidence admitted, to be debating whether you should allow witnesses, is to be debating whether you should have a cover-up, by definition. There's no other way to look at it. It doesn't matter how it was done some time ago. It was done very fairly, as it happened some time ago. But it doesn't matter. It cannot be used as an excuse. The only reason to oppose bringing a witness is to cover up because you're afraid of what the witness will say. The question before the Senate is, do the Republican senators want to be complicit in the cover-up of the president? Any senator who votes to deny a witness, who votes to deny evidence, is voting to cover up the president's crimes and subversion of the Constitution. There's no other way about it. There is no conceivable reason to deny witnesses, to say you cannot bring in the evidence. The House of Representatives cannot bring in the evidence. There's no reason. I mean, it's obvious to say, what do they fear? Why won't they bring in the witnesses? Because they are afraid of what the witnesses will say. But there's no trial in this country in which you wouldn't admit the relevant witnesses, in which it's even a question.
Let's go to questions.
Do you even need the full 24 hours to make your case, and are you going to use the full 24 hours even to go through tonight?
You know, that will be a decision that the House should make, not that the senators should prescribe to go late into the evening. Look, there is a wealth of evidence to present here, and we should have the opportunity to present the case as the House chooses to present its case, not to go late into the evening when Senator McConnell evidently hopes the public may not be watching. And so we'll make decisions about how long our case should go within the rules that are prescribed. But I think the question is, what is the senator's interest? What is Senator McConnell's interest in structuring the trial this way? Is this about hiding the evidence from the American people with late-night sessions? Is this about just trying to get it over with? Because that should not be the motivation here. Senator McConnell has taken the same oath as every other senator in that chamber, and that is to do impartial justice, not to try to skew the process in such a way where the House is not permitted to put its evidence before the American people.
Do you worry that all this focus on rules and process and what Senator McConnell is doing dilutes in any way the message you're trying to put out about what you think President Trump did?
No, because look, this is part and parcel of an effort to cover up the president's misconduct. That was the whole object that is charged in Article 2 of the impeachment articles. And if the Senate and the Senate leadership will not allow the House to present its case, will not allow the calling of witnesses or presentation of documents, if Senator McConnell makes this the first impeachment trial in history without witnesses or documents, it will not prove the president innocent. It will merely prove the Senate guilty of working with the president to obstruct the truth from coming out. And so I do think that by structuring the trial this way, it furthers our case that what's going on here really is a cover-up of evidence to the American people.
Who would you like to hear from the most?
Well, and I'll ask some of my colleagues to add on as well. But look, there are a number of key witnesses, I think, that we know even at the outside of the trial should be called. And there are people like John Bolton and people like Mick Mulvaney. There are people like Michael Duffy and Mr. Blair and others. But if we're proceeding in a logical fashion, if we're truly interested in a fair trial, the first step ought to be the production of the documents. Those documents will reveal precisely who the most important witnesses are. And they may be those four, and there may be others as well. Let me just give one illustration of what's being hidden from the American people. We have text messages where high-level people in the diplomatic corps are asking each other, are we really withholding military aid? And as we talked about last night, I think it's crazy to withhold military aid to pressure an ally to get help with a political campaign. Okay, those documents have not been provided by the administration. They don't want the American people to see them. Now, we have seen them because cooperating witnesses did provide them. But documents like those are being withheld from the public. That is the kind of cover-up that the president is engaged in, and the Senate should not make itself a party to that. So, just to conclude in terms of witnesses, we should review the documents. The House should have the right to call witnesses. The president should have the right to call witnesses. Material witnesses, not witnesses just for the purpose of smearing his opponent, but material witnesses. That's what makes a fair trial. But let me ask my colleagues who haven't had a chance to speak if they'd like to add. Okay. Last question.
How much does it hamstring you to not be able to have to know which witnesses and documents are going to be admitted while you're making your case?
Well, it's as if you're on jury duty, and the judge were to come in the courtroom and say, I've been talking to the defendant, and we've decided I'm not going to let the prosecution call any witnesses, and I'm not going to let them call for any documents. I'm only going to let the prosecution read from the cold record in the grand jury. And even then, we won't necessarily decide. You can consider that as evidence. That makes it impossible to have a fair trial. Not just difficult, but impossible to have a fair trial. And I think for senators who take their oath seriously, and I hope and pray that they do, this is not the fair trial that the American people want. It's not the fair trial the American people deserve. Thank you.
All right, Democratic House impeachment managers speaking ahead of the start of the President Trump's impeachment trial in the U.S. Senate. Today, the Senate is deciding on the rules governing this trial. They say that the Republican leaders' proposed rule, Mitch McConnell's proposed rules, do not describe a fair process, a fair trial. Adam Schiff, whom we heard from there, said that this is not a process for a fair trial, and it's a process that allows the president, he said, to continue to obstruct the Congress. He also said that Mitch McConnell's evidence and witness rules are a departure from the Clinton impeachment trial, a lot of comparison with the Clinton impeachment trial, and he added that this is part and parcel of an effort to cover up the president's misconduct. Let's speak to Heidi Zhou-Castro on Capitol Hill for us. Heidi, the dispute over witnesses really is the key friction point between Democrats and Republicans in anticipation of the start of this trial in the Senate. What can Democrats really do about it at this stage?
Well, they certainly do not have the numbers to vote down this resolution fully. As you know, Republicans control the Senate, and there would have to be at least 4 of them who vote against McConnell's resolution or approve amendments that we expect from the Democrats. And so far, not a one of those Republicans have said they're willing to do so. We're expecting a purely partisan vote approving these proposed trial rules in the coming hours. What Democrats can do, and as you saw them just now making that press conference, is make this pitch to the American people to try to communicate to voters what a fair trial should look like. This was quite an educational press conference in a sense. You saw Adam Schiff, the lead House manager, the prosecutor in this case, saying that there is no fair trial without evidence. And he's pointing out this key point of contention that really has incensed Democrats about this Republican proposal, and that is the lack of a guarantee to introduce the currently existing evidence into the trial record. What does that mean in layman's terms? Well, it means that the 17 witnesses who we've heard from in the last months and the text messages, so much that we've reported on, that would not form any sort of legal basis for the senators to consider when determining whether or not the president is guilty of these charges and thus should be removed from office. Rather, without that guarantee that this evidence should be considered, the senators may have an excuse to say that there's no legal basis for the arguments that we'll hear. So really, Republicans trying to take away the fundamental building blocks, the legal building blocks that Democrats say are essential to arguing their case and to proving what they think is abuse of power and obstruction of Congress on part of the president. And that is what has them so outraged, because it is an extreme departure from what we saw in the last impeachment trial, that of Bill Clinton 21 years ago. That is the House evidence at that point, or the independent counsel evidence, was automatically part of the trial record for President Clinton's impeachment trial. That will not be the case here for Trump. It doesn't mean that it can't be called into the record later on. It just means that postponing that decision and not having that guarantee means more partisan opportunities for Republicans to move to not include that evidence. And of course, the same concerns regarding the Democrats' demand for more witnesses to be called. And that is why you just heard the Democratic prosecutors, the House managers, say that this will not be a fair trial at all, because under this proposal, Republicans, they say, are trying to basically get rid of all the evidence that which is existing, and also no guarantees for calling or for the development of more evidence with new witnesses to be called.
Okay, Heidi, thank you very much for the moment. Heidi Zhou-Castro live for us on Capitol Hill.